This is the healthcare decision making at a time of crisis and beyond. Make sure you're in the right session. My name is Karen Memphis, and I know I keep saying the same thing, but if you've been in my introduction before, I apologize. I'm a shock trauma nurse. I work in the traumatic brain injury unit, and I'm also fortunate to sit on the board for the Brain Injury Association of Maryland. So for me, I get to see the critical care side of their injuries and then be in the community and see how it affects them long term. So I feel very privileged that I have the ability to do both. Today, we're very privileged to have Mr. Stephen Elville be our presenter. He is the principal of Elville and Associates. Mr. Elville's work is centered in elder care, special needs planning, and estate planning with special emphasis in the areas of tax planning and assessment production, which I'm sure is very interesting now with the new changes in the tax laws. He earned his law degrees from the University of Baltimore, cum laude, and is a member of the Academy of Special Needs Planners, the National Association of Elder Law Attorneys, and the National Network of Estate Planning Attorneys, among other organizations. Mr. Elville currently serves as a member of the Maryland State Bar Association Elder Law Section Council and the Charitable Gift Planning Advisory Committee for Anne Arundel Medical Center. He was also named in the 2018 Maryland Super Lawyers list again this year. Thank you.
Thank you so much. Good morning. How's everybody? It's a little chilly outside, but it's at least warm in here. And so I'm very privileged to be back this year to talk at this wonderful conference. So thank you for having me. And I realized right from the beginning that I'm surrounded by different types of people here. Some medical professionals I happen to know personally, and others. And I just wanted to ask, how many of you, if anyone here, is actually dealing with a loved one who has had a brain injury or is dealing with a situation like that currently? So at least one person. Okay. And so as we get into this material, I know some of this is going to be pretty basic for some of you as medical professionals, and maybe today you'll get a little bit of a feel from the legal side of how we see it. Obviously, I'm not a medical professional, I'm an attorney, but we can't do a good job in elder law unless we really avail ourselves of the resources of medical professionals or geriatric care nurses and doctors and so forth. So just know that I'm going to be talking to you today from the legal side. Some of you may know a lot more about this than I do on the actual medical side, but I'll try to give you a perspective on that. Okay, so we have a lot of things to cover. I was hoping today would be more of a real workshop feel. I have a lot of handouts, and a lot of this information is on the Attorney General's website, so I want to make sure you're very aware of that. So how many of you have ever been to the marylandattorneygeneral.gov? So that's one of the reasons why we printed out all this material, is because a lot of wonderful resources about this subject, healthcare decision making at a time of crisis, a lot of wonderful things I'm going to point out to you that are already on that website. So there's no mystery to a lot of this. It's not magical. This stuff is available, and you just have to take the time to read it. So I'm going to give you an introduction to this material today, and hopefully in your spare time you'll actually read this, because it is really a wonderful guide to Maryland healthcare policy. So let's just get into this, and if you have questions, hopefully we'll have a little bit of time at the end. We're going to do the PowerPoint presentation, and also, which you have all that in front of you as well, and then we're going to do a little hands-on with some of the forms. And with the medical professionals that I know we have in the room, I would welcome their input. Okay, so what are we going to cover today? Healthcare decision making in Maryland, what is it? I'm going to try to give you my view of it, and the official policy view of it. Putting healthcare decision making into context. What is the real world, what's actually going on out there in the real world in the context of healthcare decision making? Advance Medical Directives, what are they? Understanding surrogate decision making, which you'll find from me today. I think that's one of the most important things I could convey to you today, because even though I've never had anyone in my particular family that's had a brain injury, I've dealt with a lot of folks that have been very lucky to have been referred to me for me to work with them that have had brain injuries. So my thought about the surrogate decision-making element is that that's one of the most important things to families who have had someone suffer a brain injury, because do most people really have these advance directives in place? Hopefully a lot of people do, but A lot of people don't. So we can't assume that the person that has suffered a brain injury has actually appointed a healthcare agent. So that's why I think knowing the surrogate decision-making rules is going to be helpful, especially to you, ma'am, in your particular situation. Understanding and making sense of MOLST and POLST, the medical orders for life-sustaining treatment. Okay, so first of all, when we look at our handouts, we need to know that the Annotated Code of Maryland does cover something called the Health General Article. Now, this is boring stuff, but it's really good stuff for you to know in this context. So just know the Annotated Code is online. You can read it at any time. But the Health General Article, Subtitle 6, called the Healthcare Decisions Act, that is where the healthcare policy is, okay? Just so you know that. Now, I've given you the summary, if you can find this particular thing. It's called the Summary of the Maryland Healthcare Decisions Act. This is one of the best things I think the Maryland Attorney General does, is put out this kind of healthcare information. And I'm just going to give you the highlights of this because we want to cover a lot of information today. But if you'll look at this, and obviously this is not what we would call rocket science, but it really just talks about the three major end-of-life situations. It talks about informed consent, which we're going to talk about, the doctrine of informed consent. It talks about advance directives and the legal requirements. So if you look at page 2, one of the nice things about advance directives is they're very informal. Do we need to be notarized? Does it need to be notarized? No. An advance directive only needs 2 witnesses. We just need to make sure that it's not the healthcare facilities personnel that are witnessing. They're not allowed to do that. So these are some basic things. As you read through this, you'll know 95% more than anybody you know about healthcare decision making just by reading this little summary. It talks about the authority of the agent. What is the agent's authority? Do we want to place any kind of limitations on their authority? When we actually get into the advance directive, we'll talk about that. Pregnancy, organ donation. And then, as I mentioned on page 3, surrogate decision making. Can a surrogate do all the same things that a healthcare agent could do? Well, no, and we're going to find that out here in a little bit. But it's a wonderful thing. Most people do not know that there is a lesser restrictive alternative to guardianship called surrogate decision making. So when I'm sitting in a conference room with someone in estate planning, and we're talking about financial powers of attorney, and healthcare directives and healthcare powers of attorney, I always ask, if for someone who's married, I always say, can a spouse make healthcare decisions for you if you have no advance directive? And at least 50% of the time, they'll get that question wrong. They'll say, oh yes, or excuse me, they'll say, no, she can't, or he can't make decisions for me. And the answer is yes, they can. So surrogate decision making is an alternative or substitute for guardianship. But on the financial side, is it possible to have a surrogate? And the answer is no. So on the financial side, if I have no financial power of attorney and I was incapacitated, I would have to have a guardianship of my property, and that's just something we'll cover in a little bit. But my point is that there is a surrogate decision-making mechanism for healthcare. And then it talks about the standards for surrogates and so forth. Then it gets into the MOLST. And many of you are familiar with MOLST, but for those of you who are not, I'll do my best to describe how I see it and how other states see MOLST. And you'll find out from my perspective that most people don't know about MOLST, and they certainly don't know about the MOLST worksheet, which we're going to talk about. And they don't know that Maryland is the only state in the United States that requires MOLST. So that is something that most people don't know, and you're going to be educated about that today. All right, so this is a very valuable summary. So again, I cannot emphasize that enough. But where is the real law? The real law is in Subtitle 6 on the prior slide, and this is the actual text. Now, we did a lot of printing for you today. We did a lot of handouts. This is something I did not print because I didn't know if you'd really want to read this legal stuff today, but this is the actual text of the summary. This is the summary from the actual text. So if you go on marylandattorney.gov, marylandattorneygeneral.gov, you can see the text here and you can print that out. And I really recommend, if you're serious about healthcare decision policy in Maryland, you read this. It's not that thick, and it's not fine print, and I think you'll get a really good feel for the best interest standard and all kinds of things that we need to know about. But just know, these two things are online, easy to get, and it's important. So the summary and the text. If you don't want to print it out and you just want us to email it to you, all you have to do is send us an email, talk to us afterwards, and we will email you a text, the text that I'm talking about. All right. Now, the doctrine of informed consent. Let's keep moving here. This just basically says that a patient has to consent to treatment. This is common sense, right? The patient has to understand the risks, benefits, and alternatives to treatment, and its protection against unauthorized contact. Now, I'm being kind. This is really saying assault. Someone who's contacted or they received contact that they are not consenting to. That's an assault. So we're trying to prevent that with the doctrine of informed consent and, of course, the right of self-determination. So when someone has an advance directive, they name what? Their healthcare agent. And we talked about this just a minute ago, avoiding guardianship. So when you name your agent, you are avoiding guardianship because you have an agent to act for you. A court doesn't need to act for you. Now, of course, you also can avoid guardianship by having the surrogate, so on the healthcare side. But the right of self-determination has to do with avoiding guardianship and not losing your legal rights to your person. All right, so let's talk about the best interest standard. I'm going to take just a few minutes to read to you. You don't have this in front of you because I didn't print the act, but Maryland has or abides by what we call the best interest standard. And a lot of this is common sense, but let me just get you familiar with that. The Attorney General or the Code of Maryland describes best interest means that the benefits to the individual resulting from the treatment outweigh the burdens to the individual resulting from the treatment. Very simple. The benefits outweigh the burdens, but here are some further fine points. Taking into account that the effect of the treatment on the physical, emotional, and cognitive functions of the individual, or taking into effect the treatment on the physical, emotional, and cognitive function. Taking into account the degree of physical pain or discomfort caused to the individual, or the withholding and withdrawal of treatment. Taking into account the degree with which the individual's medical condition, the treatment, or the withholding or withdrawal of treatment result in severe or continuing impairment of the dignity of the individual by subjecting the individual to a condition of extreme humiliation or dependency, and four more. Taking into account the effect of the treatment on the life expectancy of the individual, taking into account the prognosis of the individual for recovery with or without treatment, two more, taking into consideration the risks, side effects, and benefits of the treatment or withholding or withdrawal of treatment, and the religious beliefs and basic values of the individual receiving treatment, to the extent that these may assist the decision maker in determining the best interest. So that's a mouthful, right? So that's the best interest standard. And a lot of states look to that standard. So the doctrine of informed consent, the definition of the best interest standard, you're not going to see that in the summary. You're going to have to look at the text for that. But these are very important things for you to know about healthcare decision-making policy in Maryland. Now, let's put this into context. How do you prepare for healthcare decision-making in Maryland? Well, through documents. So I'm going to show you a couple of very simple examples of how you name an agent and what you can expect in that regard. But many people are not aware that you can make an oral advance directive. Now, when we get into the brain injury context and this kind of thing, to me, from the legal side, this is one of the most important things for families to know. Because a lot of us don't have any estate planning at all. People that are aged 30 to 44, 80% have no estate plan. So that just tells me 80% of them have no advance medical directive. So is it important for your loved one or your family members to know that even if you don't have one written, you could make an oral advance directive? You could also make an electronic advance directive. You can make a video advance directive. And the state of Maryland actually has a registry. Now that registry is supposed to be active now after last year's legislative session that said you better get it active, because I think for 30 years it was inactive. So I wouldn't put a lot of stock in it right now, but maybe I'm wrong. But the state of Maryland has a registry and you could use it. There are also some private registries like DocuBank, and I think another one called Advance Directives Unlimited or something like that. There are services out there where you can sign an advance directive and put it online. So anywhere you travel in the world, it's available and so forth. But the state of Maryland does have a registry. So an oral advance directive, if you say, or your loved one says, I want to make an oral advance directive, the physician is supposed to go into action, and the nurse practitioner to memorialize that in writing, and there you have it. It's an advance directive. So you see, this is very informal, it's very easy, but most people don't know you can do that. And then surrogate decision making. So let's get into that. All right, so the context. Let's talk about estate planning. And so this is pretty simple. If someone did basic estate planning, which we're not here to talk about, but you'll notice that part of good estate planning is to cover the Advance Medical Directive. And then you'll see in fine print down there, you'll see the MOLST form is in there. To me, we need to have a basic understanding of the MOLST. How does that relate to an advance directive? And the healthcare decision-making worksheet. Okay, you'll hear me mention this a couple times in this presentation. We had a client event about 3 or 4 months ago, because my firm has a client event every year in October, and we had the head nurse from Anne Arundel Medical Center come to our, or one of the head nurses, I should say, come to our seminar, and she was very kind to present. But she found out that most people in the audience don't know anything about MOLST, have never heard of it. And I'm getting ahead of myself just a little bit, but you'll see this MOLST worksheet we're getting ready to talk about in a few minutes. And definitely no one had heard of that, and I don't think she had even heard of it. So that's why that's up there. We need to know about that. And I'll give you one other reason why we need to know about it. As we get ready to get into that discussion, just know that in the last 60 days, I've probably had 7 or 8 families in my conference room that have a loved one at assisted living or in the nursing home or in a rehab center, and almost none of them had ever heard of MOLST, and none of them had ever, didn't even have an idea that the physician had put a MOLST form into place for their loved one. So that's the scary part of it, and that's why we're going to cover that. A little bit ahead of myself, but I just wanted to cover that there. Now, if someone has a revocable trust plan, which is a different kind of estate plan, we're not going to spend hardly any time on this, but you'll notice they still need an advance directive to go along with that. So whether they have a will or trust plan doesn't matter. In the basic context of estate planning, an advance directive is a basic document to name healthcare agents, make it, and we're going to talk about the purpose of the directive, but to avoid guardianship of the person. So that's what we're talking about here. On the financial side, powers of attorney avoid guardianship of the property. On the healthcare side, we're avoiding guardianship of the person. And this little chart we won't spend too much time on. It's a little confusing, but if you take a look at that, it will give you an idea of why these documents avoid the prospect of guardianship. Now, is it possible for someone to have these 2 forms here, the powers of attorney, advance directive, and still have a guardianship? Yes, it's possible. How? Well, they either run out of agents because they didn't keep the documents updated. How many years go by between document updates? Any guesses? You've been reading. 19 years at a time, so that was a very good guess. So is there a good possibility these forms are outdated? Yeah, so you can run out of agent. What's the other way a guardianship can occur? You've got great agents, but then all of a sudden one day they have a dispute. And sometimes that can lead to guardianship. So there's not much we can do about that, but just know that we're trying to avoid guardianship by having these documents in place. All right, what is an advance directive? Well, many of you are very familiar with this, so forgive me for getting very basic here. We think that our clients think that the advance directive is the most important of all their estate planning documents. Definitely, it's probably the most customizable of all documents. So if you were to just take a look at this in your spare time, you'll get an idea of just how much that advance directive can be changed. It can be updated and modified. Do most people modify or customize their advance directives? No. They just don't think through it, or they don't want to think through it, or they don't use their imagination. But I'm trying to get you to advise your clients or to advise your loved ones to use their imagination and make this as personal as possible. Now, for those of you who work at hospitals, you'll have to forgive me for this, but my understanding is that at least Anne Arundel Medical Center, which I understand is the third busiest hospital in the state, they are handing out this form that we gave you called the Conversation Starter Kit. And maybe you've seen this. It's very basic, but it's designed to get you to talk to your family members and stimulate your thinking about your healthcare decision making. So this is from a nonprofit organization. It's got our logo on it. I think we paid like $3 for 100 of these. You know, this nonprofit makes this available. But just know this is very important, and it's a tool that can be used to start thinking about how to customize your advance directive. All right. Why do I hold up the conversation starter piece? Because hospitals are telling me that the advance directive is not enough these days. They're saying they don't have enough information, and they want to get as much information from patients as possible. What does an advance directive do? Well, it's general instructions. About the present? No, about the future. What about a hypothetical situation in the future? Is it technical? No. When I was a young lawyer, I thought, gosh, this thing's technical. But looking at the MOLST form, it's not technical at all. The advance directive, compared to the MOLST form, is very general. It indicates your choices, preferences, and philosophy about guidance at end of life. Okay? So that's a very good point. What is your philosophy? What is your loved one's philosophy about their health care? This is the place to indicate that. The Attorney General's form that we're going to look at in a few minutes is completely customizable with no limits. It appoints healthcare agents. Since 2010, roughly, it allows for flexibility. How many of you knew that you could say, well, these are my choices at end of life, but if I provide for it, my healthcare agent can change my decisions? That was not the case when I was a brand new lawyer years ago. People came in, they did their advance directives, and they were very happy because it was a huge decision to do that. And you made your choices, and that was it. Nowadays, you can make your choices and provide for flexibility, which I think about 80% of people do. Organ donation or body donation choices and final arrangement instructions. These are all the things that you can do with an advance directive. Now, what is the role and responsibility of a healthcare agent? And if you go back to this summary, you'll see what is the role of an agent. You know, it's very general, but let's get into it. To advocate for the patient. This is why we think you need to know about MOLST. How can you properly advocate for your loved one or a patient without knowing about MOLST? Determine the facts and access medical records. So the advance directive has a HIPAA waiver, right? So you want to be able to access records at the time of crisis. Collaborate with financial agents, okay? Is healthcare expensive? Yes. So you want to be able to collaborate with other people who are financial agents. Understand the patient's healthcare choices and follow their instructions. Makes sense, right? Advocate for them. Be readily available. That's a big issue. Is my agent really going to act for me? Am I appointing someone who's going to really dig in and be my advocate? Now, can you be an overzealous advocate? Yes. And sometimes that's not a good idea, but zealousness is a good thing, generally speaking. Participate in care planning meetings. So this is just a few ideas about the healthcare agent's role. Now, I'm going to take a little drink of water and check my time. So we're doing well. We're only about 28 minutes into the presentation. So we're going to get into the surrogate decision making now. Who can make decisions for another? And let me put this into context really quickly. My assumption, and maybe it's an incorrect assumption, is that many of the brain injury cases I've had the privilege of working with, the victims and so forth and the families, it seems to me that most of them had no estate planning documents when this happened. Now, this is not always true, of course, but let's pretend that most of them had no documents in place. And now, hopefully, there's some rehabilitation or the person is able to resume somewhat of a normal life, which is not always true, but hopefully it would be true. And when they do resume their normal life, hopefully they have the mental capacity to sign advance directives and powers of attorney, okay? But if they don't, let's pretend they continue in that pattern where they don't have documents, that's why I'm saying surrogate decision making, and for the family to understand that there is a list of priority of people who can make decisions. That's very important, because what if this person does not have an advance directive? So let's look at one of the things I printed out for you. And this one's dated. Now this one is by Attorney General Jack Schwartz from 2008. It says, Making Sense of Living Wills. What I'm going to show you here is not this whole thing, but although you should read this, it's not a bad presentation. Jack Schwartz was a very proactive attorney general that was in charge of, healthcare decision making and this kind of thing. And so there is a slide in here I want to show you that shows the order of priority. Let's look at page 5. It says 5 down here. And you'll see the order of priority for surrogates, okay? And if you get to there, it says guardian of the person, spouse, adult children, parents, adult siblings, and other relatives. So you see this order of priority. So to me, one of the most important things we can talk about today is the order of priority, so that you know, even with your brain-injured loved one, that you have this ability to make decisions as a surrogate, even if they don't have an advance directive. So hopefully you see that order of priority. It's also in the text of the Healthcare Decision Act. All right, what are the powers and limitations of a surrogate decision maker? You'll see that in the summary that I gave you. The best interest standard, we talked about that, okay? And the Attorney General's PowerPoint. Now I want you to look at something I think is really something I have to admit I didn't even know was available until I was preparing for this, which is this decision tree. I don't know if you've ever seen this, but the more I looked at this, the more I was impressed. And it gives various situations. For example, what if there was an advance directive? What if there is no advance directive? What if there's only a surrogate acting and no agent? If you take the time to look down this decision tree, I thought it was very, very well done. And if you're a surrogate decision maker, and let's look at, I guess, the 4th page back, it says, no agent, chart number 4, no agent, surrogate available. Surrogate is available. Then on the back it says, no advance directive and no surrogate. Okay, that's a bad situation. That means we might need a guardianship of the person. But if you take the time to read these very basic decision tree items, I guess, you'll get some real clarity about how things work. So at a time of crisis, I'm very impressed by this. Pull out this decision tree, use the tools that are being made available to you. Oh, I'm sorry. You should have this, and if you don't have it, it says life-sustaining treatment for incapacitated persons, algorithm for physicians. Now this is obviously, you don't have that? We don't have that handed out? All right, so that tells me Jeff probably didn't see this yet, and we're going to make sure. Lucy, where's Jeff? Why don't we find him, and we're going to get this handed out to you, and if not, we're going to send it to you. But this is incredibly clear to me, and I'm not easily impressed, and this is, I think, very impressive. Yes?
For the domestic partner, how do they prove that? Because for us, we don't allow that if the family says no.
Right. On the financial side, there is a domestic partnership agreement. On the healthcare side, I'm going to have to look that up, and if you'll email me, I'll give you an answer on that. All right. But for those of you who don't have it, I guess we didn't hand it out. Let's just go through this really quick decision tree for when the surrogate was available. And it talks about, are there surrogates of the same level? And if there are, there has to be agreement, and then it just kind of goes down through the decision-making process. But I think as an agent, this would be very valuable to you. Lucy, do you happen to see it back there? It could be something that Jeff just overlooked. Let me just take a quick look at it. If you could hold it up. That's it. Okay. So let's get that handed out and we'll come back to it.
Could I ask you a question about the priority surrogates?
Yes.
So, like when it comes to adult children, does it then go in the order of the adult children? Or is the adult children, do they all get to vote?
All right, so let's get into that. And the question was, what if we've got several adult children, and what happens if we've got, let's say, 3 children of the same priority? So I'm going to go right to the text here. And as you look at the decision tree, I'm going to try to answer this question right from the text. All right, and in the text itself, you'll see much more detail about the order of priority. But Sue, it says, if persons, and I hope this answers your question, if persons with equal decision-making priority disagree about a healthcare decision, and a person who is incapable of making an informed decision is receiving care at a hospital or related institution, the attending physician or individual specified, meaning the surrogates, shall refer the case to the Patient Care Advisory Committee. So if they don't agree at that level, if they don't acquiesce to one another and say, okay, you can act as the surrogate, and they disagree, then it has to go to the advisory committee. Did that answer your question? Okay. All right. All right, what is MOLST? It was effective July 2013, but it didn't become actively required until 2014. This is a medical order, and you have this in your materials, so let's take a look at it. I was at a hospital the other day doing a signing of a patient who was not well, and I saw people running up and down the hallway with MOLST forms, so I know they're being used everywhere. All right, and for those of you who are medical professionals, please chime in on this discussion. It relates to the current medical condition, not the future, to the current. This is hard to get your mind around if you've never really discussed MOLST, so we're going to take our time on this. And for the family of the brain-injured person, to me, this is very, very important. So we could talk about advance directives all day long and all that, but surrogate decision-making and MOLST, to me, is the most important thing today. There is a worksheet. You'll see this here. Healthcare decision-making worksheet. Okay, I think that's very, very important. This is the actual MOLST form. Does everybody have that? Okay. If you don't have it, please tell me. There's a lot of confusion about the actual MOLST form versus the worksheet. Okay. And the Attorney General has publications about this again, marylandattorneygeneral.gov. Some states call this POLST, Physician's Order for Life-Sustaining Treatment. It's basically the same thing. It's also advanced instructions about end-of-life choices. It's to enhance the quality of care at the end of life. It provides a guide for treatment from one location or one setting to another. It was designed to provide continuity. And it's supposed to be, and I'm hoping it is, a consultation between the physician and the patient, or between the physician and the surrogate. So remember I said those 7 or 8 families had been in my conference room in the last 60 days, and none of them seemed to even know what MOLST was, but guaranteed there was a MOLST form signed by the doctor or nurse practitioner. So that consultation is supposed to be happening, and I hope, of course, that it was happening in those situations. But the advocates, the people who are the loved ones taking care of those patients, did not even know about it. Okay, why was MOLST implemented? We're going to get into this now. You're going to see this is from the Attorney General's website. To better implement the provisions of the Healthcare Decisions Act. A lot of people say, what is the policy reason behind it? Well, there it is. To simplify the process for healthcare providers, to minimize or avoid errors, to standardize the care across different settings, to significantly increase compliance with the patient's wishes at the end of life. We're going to come back to this. Now, I got this from a wonderful publication I got from the National Academy of Elder Law Attorneys Symposium from a New York speaker. Why was MOLST implemented? To facilitate communication of medical orders impacting end-of-life care for patients with advanced chronic or serious illness. It's actionable medical orders that can be followed by emergency personnel. And it's a proven national model. Okay. Who is MOLST designed for? This is a lot of confusion about this. Individuals with advanced progressive chronic illnesses. I don't see anybody in this room that I would say needs a MOLST form. Now, I'm not a doctor. Okay. You're not in a facility. You're not elderly. You're not frail. You don't have an end-of-life condition. So my humble opinion is you do not need a MOLST form. But you might need a MOLST worksheet. We're going to get into that. Because you can sign a MOLST worksheet. You can't sign a MOLST form. All right, individuals who are terminally ill need a MOLST. Individuals who proactively wish to define their health care wishes in detail. That's what I was just saying. You don't need a MOLST form, but maybe you need a MOLST worksheet so you can define your wishes. Maybe you're the kind of person, or your survivor of the brain injury is the kind of person that wants to articulate everything in fine detail. That's where you would use the MOLST. Now, do you have to start worrying about all this MOLST stuff? Not necessarily. You could just say, or your loved one could say, I'm going to leave it up to my surrogate or my agent to take care of it in the future. But all I'm saying is it's fine either way, but the agent needs to know about it. And of course, individuals who are frail or aged. MOLST, and I'm repeating myself to some degree on purpose, MOLST may also be appropriate for individuals who want all treatments, individuals who wish to avoid all treatments, individuals who want to limit treatments. And we're going to get into this worksheet here in a minute. Individuals who wish to avoid CPR, individuals who may die in the next 12 months, people who reside in long-term care facilities, people who live in the community but are eligible for long-term care. I have a relative who has liver cancer, and he's not in a facility, but when I showed him the MOLST information that I showed you today, of course it's readily available on the internet, he showed it to his doctor, and the doctor says, yes, you should have a MOLST form. So that's an example of a person living in the community that needs a MOLST form. And again, hospitals are saying advance directives are not enough. Sue, do you have any comment on that at all? Do you think that's an overstatement? I know I'm putting you on the spot.
I would tell you that I'd be interested in who's saying that. Because we are pretty religiously using the MOLST forms.
Okay.
And I go to several different institutions. And you see the MOLST forms. It's a little disconcerting to hear you say that people have signed ones, because I will tell you, we are definitely, if we discharge someone from the hospital and they're not going home, we're not allowed to discharge them unless they have one of those with them.
Okay.
Because of the EMS component of travel.
Okay.
So I think that there is a disconnect between conversations that are had and that the information is being put on a form called a MOLST. Do you understand what I'm saying?
Yes,
Like, I don't think that anybody walks in and says, hey, we got this form we got to fill out called a MOLST, so let's talk about it. I think we talked to you about end of life related stuff, and the doctor goes and fills out the form.
Okay.
So but I have not heard that the Advance Medical Directives are not.
Is it possible they're saying exactly what you're saying, that you are religiously using the MOLST form, so they're kind of saying, well, these advance directives don't really mean much to us anymore? Is that possible?
I guess it could be.
Yeah. So these are the things that, yes, ma'am.
I have a comment on that. So for me, I work in trauma, and our patients, it's trauma. They may not have that kind of stuff already available. But for us, advanced directives, unless you go into the stuff that you're doing, are so general that it doesn't apply. Because it'll say if it's an irreversible, all it says is an irreversible condition where two doctors think you're not going to. So it's not specific enough if you have just a plain addiction. So for us, it then leaves it up to the physician. There has to be two physicians that, what I think might be aggressive treatment might not be what somebody else thinks. And we know there is a doctor at our institution that there never ever is a time if you ever give up. So that's the problem with advanced directives. So that might be more what people are referring to. It's too general.
I would totally agree with that.
Okay.
I mean, that the part of the struggle is they say, and trauma is a perfect example of, someone, like anybody in this room, drives out of here and gets in a terrible car accident. They probably didn't have anything, or if they did, then it talks about this terminal condition stuff. Well, they weren't in a terminal condition, but now because of this accident, they may be in a horrible condition. And then so the conversation then has to be had with whoever's the surrogate or healthcare person. And it tends to be a lot more specific, and so it does travel. But none of us in this room would be having a MOLST just like in our back pocket. So,
Right.
that's, if you had a car accident, that'd be irrelevant.
Right. So we'll talk about document storage here in just a minute, and the MOLST worksheet. Very, very good. Yes,
I
ma'am.
just want more things on that. I can guess.
Go ahead.
So she said you wouldn't have it, but we recently had a patient with a MOLST on their physician, but their healthcare agents did not want to honor it. So our institution said that legally we had to go with what the healthcare agent said, which, because the patient had done the MOLST with his physician, apparently didn't tell him. He didn't know what we were doing to him, but his children didn't know what we were doing to him. So
And the patient was without mental capacity?
Correct.
Okay, well, I would agree with the hospital's position on that. If the person said that their child had the flexibility to change their decisions, and that would be in the advanced directive, if they had chosen that flexibility option, which we're going to look at in just a second, then I would agree with the hospital on that.
So this is the way that you can avoid that. You don't do the flexibility.
Right,
The
right.
other thing, just when after I do the infection practice with the family, and I tell them this is really useless because it doesn't say. But I tell people that you better pick a healthcare agent that will honor your wishes, because probably when we have one time that the healthcare agent says, they can really upset because they know that I'm doing what they don't want, but I just can't do it. So I really encourage my families, maybe you need to pick a person that hates you first. So they'll do what you want. You know what I mean?
We'll edit that out. No, I'm just kidding. All right. Thank you very much for that input. That's wonderful. On the ground input. Thank you. Okay. So MOLST can enhance the advanced directive And now let's take a look at that worksheet, and I believe we're almost done, but sorry. Well, now I've really messed things up. I didn't mean to do that. Lucy, could you fix this real quick? Okay. So let's take a look at the MOLST worksheet, and we have about 15 minutes left, and we're going to end on time. So let's take a look at that worksheet, and I'd like to give your input on this as well. So my problem with all of this is I think the Attorney General is trying to get that information out there, but as Sue mentioned, there's a communication problem. Okay? And it doesn't mean it's their problem, it just means we just got to educate people.
Is this the slide you want?
The one right before that.
That one?
Thank you. So, in the interest of time, let's just look at this. This can be signed by you. Thank you. And we tell people in elder law and estate planning, go discuss this with your doctor. I mean, we're not medical professionals. Go talk to your doctor or nurse practitioner about this form. I think it's interesting to read the first paragraph, so let's read that together if you don't mind. Use this worksheet to indicate current treatment preferences, which will be reflected on the MOLST form, okay? Or to clarify wishes for future situations, which will be applied only when the issues become relevant in the future. Only initial those things for which a decision has been made. The remaining items can be left blank. So, in estate planning, we deal with many people who are over 50, over 60 years old, and I always encourage them, go ask your doctor, should I have a MOLST worksheet? I'm not frail, I'm not ill, I'm not living in a facility, I don't need a MOLST form. I'll tell you a really silly story. A really diligent client of mine is 59, and he came back the other day and he said, Steve, I've got my MOLST form. And I said, no, that's not what I wanted you to do. But he had actually gotten a doctor to sign a MOLST form for him. What I really meant was, maybe talk to your doctor about whether you should have a worksheet. Now, let's take a look at this worksheet. And this is above me, and my medical knowledge is very limited. But remember, this is input. Input for what you will ultimately have in your MOLST form. So I'll just ask the medical professionals in the room, if this was filled out by someone who is obviously not needing a MOLST form, and it was attached to their advance directive, would that be, for the person who wanted that level of granularity, would that be a good thing, in your view?
I think it's a good thing. I mean, because it gives the healthcare providers direction.
Okay, okay.
But they would still have a conversation with someone.
Okay. So there you have it, and I think I feel a little bit validated by that this is the proper thing to do for those people who really want to do that. And you remember one of our prior slides, the person who wants to be in fine detail about their healthcare decisions. Are there people who don't want antibiotics? There are, and they can say so right here. So thank you for that input. You have
It'll
no
help the family too.
and it'll help.
Right. Because the family then feels confident that they know what is said.
So my 59-year-old could have a MOLST worksheet attached to his medical record or his advance directive, and that seems to be a good thing. So I feel good about that. But also know you don't have to do that. And ma'am, your loved one who has the brain injury does not necessarily have to do that. You could make their, if you don't mind me asking, what is your relationship?
It's my son.
It's your son. And how old is he? Okay. And we won't get any more detail than that, but this means that you could make those decisions for him rather than him having to get that granular into this MOLST worksheet. And of course, he's only 25 years old. So I think there are people who will want to get that detailed, and there will be people who do not want to. Most of our clients that are 50 or 60 or older definitely are doing what we ask, and they go to their physicians and ask about this. So thank you for your input again. So that's where I'm going with this MOLST worksheet, okay? And I think the point has been made. Does anybody have a question about MOLST? We're going to get into this last slide. This is the difference between MOLST and an advance directive. MOLST is a medical order signed by a doctor. The Advance Directive is just a legal document. MOLST takes effect immediately. Advance Directive cannot be, the MOLST is effective immediately, and emergency medical people can follow it, and it applies regardless of mental capacity. Whereas the Advance Directive, emergency personnel cannot follow it, and it applies only when mental capacity is lost, if this helps. No age limit, and of course, Advance Directives, competent adults over 18. MOLST is signed by a medical doctor or nurse practitioner, and then of course the Advance Directive is signed by the client or patient. And remember, as we close out here and get ready to look at the Advance Directive, remember that an Advance Directive can be oral or electronic. It does not have to be written per se. All right, any questions about MOLST? Feel free to ask. I guess as we wrap up, I wanted to show you an actual Advance Directive for those of you who don't really look at these things every day. And for the medical professionals, this is day in and day out, you see these things. But I just wanted to show you that you can go to, again, attorneygeneral.gov. You can print out an Advance Directive. Every year on Law Day, the elder law section of the bar does hundreds of these for seniors, so they're readily available. They do not have to be notarized. Ma'am, I don't know if your 25-year-old has an Advance Directive, but this form is very easy. If he has mental capacity, very easy for him to sign and appoint you as an agent and all that kind of thing. Let's take a look at it really quickly. We have about 5 or 7 minutes. Page 1, we're simply acknowledging who the principal is, the person who's making the directive, and who their agents are. Now, this form is not as good, let's say, if one was hand drafted by someone, but this is legally valid. This is perfectly fine the way it is. It does not have to be formal. So we're naming an agent and we're naming a successor agent. We're on page 2 now. The agent has a lot of power. We won't get into all the powers, but they have a lot of power to make healthcare decisions, transfer you to a facility, take you to another facility, sign contracts on your behalf or the person's behalf. Now on page 3, do we want to limit the power of the agent? The agent has a lot of power. Do we want to limit it in any way? Most people don't have any limitations, but conceivably someone could have a religious or other personal limitation they want to place on their agent. People my agent should consult. Should my agent have to consult with my other agents? Should they have to consult with my then attending physicians? Whatever you would like to say, or someone in my family who is an RN. There's no limits here on what you can say. Now, in case of pregnancy, do we have any special provisions for women of childbearing years? So we have some provisions. If you ever have questions about that, we have some provisions we could provide you to stimulate your thinking about that. HIPAA waiver. My agent can get my medical records when they are serving for me. That makes sense, right? You don't want your agent to not be able to get your medical records. You could even go as far as waive HIPAA currently. I am healthy and well, I can make my own decisions, but I'm waiving HIPAA now. You could do that. Many older people will do that. When does this power go into effect? Immediately, or only when I am incapacitated as certified by 2 physicians? Okay, so we won't spend a lot of time on that, but that takes some thinking for some people, okay? Now, we get to the living will. Statement of my goals and values. This is page 5. Do we want to say anything? Remember that slide that was up here about where do I want to live? What are my preferences? All of those things. We encourage you to expand on that. Now, on this particular form, you can't expand too much, but you could attach an additional page. There's no formal requirements that say you can't do that. Terminal condition, end-stage condition, and vegetative state condition. We don't have time to get into all those, but those are described not only here, but they're described in more detail in the summary, remember that, of the Healthcare Decisions Act, and they're defined in the text if you would like to receive the text or print it off the internet. Pain relief. I've never had anyone, well, one person out of all the clients we've ever had that refused that. But we're going to make the assumption that most people will say, yes, give me pain relief to relieve suffering. G, page 7, one of the most important things. G1, my agent can change my decisions if they think something is better. G2, my agent cannot change my decisions even if they think something is better. And then, of course, it's signed and witnessed. It cannot be witnessed by the facility personnel. No notarization required. Organ donation choices, I'll let you review those in your own time. We won't get into those today. And then final arrangement decisions, okay? And what the medical professionals in the room have kind of said would be a good idea is talk to your doctor about that MOLST worksheet. Of course, if we need a MOLST, that's a different story, but that MOLST worksheet could be attached to the back of this Advance Directive. Last thing I'll say, and we'll wrap up, there are electronic storage devices like services, I should say, like DocuBank and others. I mentioned those earlier. And anywhere you travel in the world, your documents could be accessible online if that's the kind of thing that you would like. So those kind of things are available. I guess we have time for maybe one question. We'll have to wrap up. Anybody have any questions? If not, I thank you for working through all that and listening and that serious subject. And thank you, Sue, and thank you, ma'am, for your input. And thank you for coming.